Good afternoon, everyone. This is Ben Thorpe, Associate Research Editor of Farm Equipment Magazine. Welcome to our latest webinar in conjunction with the Western Equipment Dealers Association. Today's presenters are Lance Formalt and John Fuchs, attorneys at Siegfried Bingham. Lance leads the firm's Equipment Dealer Practice Group, where he serves as legal counsel to the Western Equipment Dealers Association and the Equipment Dealers Association. He also represents many individual equipment dealerships and assists his clients with matters including negotiating dealer agreements and enforcing fair dealership statutes. John spends the majority of his time assisting clients and other attorneys with data, privacy, and technology matters, as well as general business management. This includes working extensively with companies involved in the equipment dealer industry. Now, before they get started with the presentation, I have two quick housekeeping items here. On your screen, there's a control panel with a Q&A icon. You can submit questions here at any time during the presentation, and time permitting, we'll look to answer as many as we can following the presentation. This webinar is also being recorded and will be shared with everyone who registered in the event you want to rewatch it later. And with that, I think we are ready to get started. Thanks again for joining us, and you can take it away, guys.
Thanks, Ben. Good afternoon, everyone. This is Lance Formalt, and I'm joined by John Fuchs. We, as Ben mentioned, we work with the Equipment Dealer Group at our firm. It's been my privilege to work with many of the dealer associations and equipment dealers over the years in a wide variety of industry issues. And we're here today to talk with you about an issue that we can kind of call it an emerging issue, but it's one that I think we've all been living with for the last, let's call it 10 years or so. But it's a topic that I thought it was appropriate to revisit in light of some changes in the regulatory environment in the U.S. and to take into account what that means for you and your dealerships. And so, we're here because, ultimately over the course of the last several years, your products and services have been changing. They've become more technology and data focused. And with that, we've seen expectations of your customers and manufacturers have changed. What's happened over the course of the last several years is we've also seen that those expectation changes now create some emphasis on changes in the laws, and what that means for you is that there's some new things that we need to start paying attention to get ready for those changed expectations, changed legal obligations. And at the front and center of all this too is just a recognition that while we focus on industry issues, and this clearly is one, this is an issue that's frankly not necessarily been driven by our industry. It's an issue that is being faced with consumers around the country and around the world, frankly, which is driving a lot of the changes that we're seeing. And so while we need to address it, it's just as a recognition that probably our efforts in this area are probably going to be more reactive as dealers than they are proactive, simply because this is a broader issue than just the equipment dealer industry. But with that in mind, we want to go ahead today and make sure that we get you up to speed as to what's going on, and maybe give you some ideas and thoughts as to some next steps that you should be taking or thinking about taking in your dealership. As a starting point, we want to look at just the overall issue about what are we talking about when we're talking about data and its application to equipment dealers. And the number one thing that really is driving a lot of this is customer data. And we've got a couple categories of data. You've got the anonymized data or aggregated customer data, which by and large is data that is a lot more flexible in terms of being able to use and incorporate into your business to help assist you in doing business analysis, marketing, things like that. But the other segment of customer data is the data that's identifiable to the customer, and John will be talking a little more about that in terms of how data is being regulated from a legal perspective today. But at the end of the day, whether you're talking about yield data or you're talking about Social Security numbers, customers are sensitive to information that's identifiable to them. And so there's a heightened degree of concern that we have in terms of accounting for that in your business practices. In addition to the customer data, of course, you've got your own data, which you want to be sensitive to and try to protect. You've got employee data that you're stewards of and have obligations to also protect that as well. And they're all, even though they're not as not necessarily as critical of a focus as to why we're here today. They're part of the whole conversation about data and data security. And so when we look at data and try to understand the scope of what we're talking about, I think it's helpful to also understand, who's involved in this process or in this conversation. And obviously, I just mentioned customer data, and so your customers are an important feature of the impact of what you do in your business with respect to data and protection of that. Manufacturers, they depend on the data that's being generated by some of the machines you're selling. They also have some expectations for you as dealers for their brands. And so that's also going to create a little bit of tension that we'll talk about in terms of how you address data in your business. And then you've got third-party vendors. And when you think about this, it's really a broad category that sometimes isn't necessarily accounted for in how you evaluate your business and how you're addressing data. But you've got vendors that you work with, that you give access to your systems. Maybe it's a marketing company, maybe it's an outsourced IT provider. Your customers have vendors that may interact with you. They may have an outside agronomist firm that's assisting them that wants to be able to access data that comes through your organization. And then, of course, you've got your own employees that'll have access to the data just as part of doing the daily in and out of conducting business. And so at the end of the day, all these folks are going to be involved in kind of dealing with your obligations and best practices that you need to be thinking about in your business as you handle data in your daily the daily grind that you have as you go about doing things. And so when we think about trying to figure out what are we going to address, what are the concerns that we have as we look at data and some of these issues. Something that we've spent some time talking about in the past has been relative to ownership. Who actually owns the data that's being generated from the machines, being generated by the business you conduct with your customer, and then who's, as importantly, who's got the right to use that data or sell that data. And so we're gonna, that's obviously an issue we need to deal with. It's a key issue, and it's been playing out in the marketplace as to how that's addressed. And so for today, what we want to really focus on more is what are your actual obligations in terms of how you address the data that you actually have in your possession in your business. And those obligations are, there's three main categories. So we've got to deal with confidentiality, which what are your commitments and obligations owed to other people whose data you may be handling. And then along with that, the security, which is the process you undertake to keep the information confidential. Talk a little bit about government regulation, actually quite a bit about government regulation, as there's been a number of changes in that area. And then, which creates obligations, obviously, on you. And then finally, as dealers, if we've got obligations, we've got commitments, then that means we've got potential liability. And so what are those, what is that liability, and are there ways that we can mitigate that through some risk management things that we can do in the business? And so those are the areas that we're going to want to focus on today as we give you an update in the overall category of data and data security. And so the first main topic that we want to dive into here relates to the issue of government regulation. And the reality is that government regulation is here. It's been here, and it's probably not going to go anywhere. It's probably going to get a little more intensive as we go through the years here. But from a backdrop standpoint, regulation of the area of data really started much more heavily in the European Union and in Canada. They're much more aggressive about consumer protection. And at the time, this is a number of years ago, a lot of the big tech companies, you think about Facebook or Google and maybe even Amazon, they fought hard against the adoption of these regulations in the other countries. But what's happened is those regulations were adopted, and even though in the U.S. we typically have taken a much more hands-off approach to regulation and kind of left it up to the businesses. What's happened is that these companies that are international in scope have frankly had to adapt their business practices to what's going on in the regulatory environment in the EU and in Canada. And as part of that adaptation, frankly, comes a little bit of familiarity in terms of how to address those things. And it's created an environment with the change in dialogue in the U.S. It's kind of created a call for some additional regulation now in the United States. And we've all seen this happen, obviously, just in the political discourse over the last year. There's been a lot of conversations about censorship and how technology is being used to maybe shut down certain viewpoints, how it's used to control information that flows, on top of the ability of everyone just to access information they think they should have the right to. And so what we've seen now is there's a little bit of a sea change in terms of the United States starting to move more towards the regulatory environment that's been going on in other parts of the world for quite a while. And every state now in the U.S. has adopted the data breach notice law for certain personal information. And so you're thinking like Social Security numbers and things of that nature, where there's actually obligations that if someone, gets into your system and gets access to that data, there are legal requirements for you to report that, in some cases to the government, some cases to notify customers, maybe have to do some investigation. So every state now has a law like that. And those have been on the books for a while. But what's happening now is that the laws are starting to shift to really focus much more on consumer control over their data and some obligations relating to security of that data. And John's going to be touching on these in much more detail. But what has started in California is something that's now continuing to go across the country, where we're looking at seeing more comprehensive laws being put in place. But by that, we mean is that they're covering more data beyond now the Social Security numbers. You're seeing things, customer data being covered, such as purchase history. The idea that certain information can be identifiable to a customer beyond just their name and number is becoming much more accepted. And as a result, it's becoming more subject to being regulated. And I think it's important, too, that we're not here today to, obviously, we're going to educate you a little bit as to what's going on in some specific states. But the goal of our conversation here is really not so much to say, hey, if you're working in California, you got to pay attention to this law. The issue is that I think it's important to note that this topic is one that's really, there's been a lot of conversation about the political divide in our country between red and blue. And while it might be expected that California is one of the bluest and most left-leaning states has adopted the first kind of law in this area, I think it's important to note that this is not a red or blue issue. This is a red and blue issue. There are segments of both ends of the political spectrum that are pretty worked up about technology and data and are looking for reasons to regulate it. And so what we're seeing now is there's other laws that are being looked at in Virginia, which is more kind of a middle of the road political state. Washington State is considering a law. Florida is also considering a law, though, which is more of a right-leaning and notably a business-friendly state. And so the message for everybody participating today is that there's change coming, and it's not going to matter just where you live. It's going to be something that's going to really impact all of us. And so what I want to do now is I want to turn over the presentation to John. John's really our expert in this area, and he's going to then now walk us through a little bit about what's going on in some of these specific laws and states that we need to be paying attention to.
Thank you, Lance. So this is John Fuchs, and I've been focused on data issues and data security now for about the last 10 or 12 years now, as it's kind of evolved from what I'm highlighting here initially of these data breach notification laws that, as Lance mentioned, all 50 states have passed one of these. So these currently apply to anybody operating in one of the US states. And if you're operating, I think, on Guam, I think that one's still under consideration, a few territories, but pretty much everywhere within the United States has one of these laws in place. They do only apply generally to specific types of personal data. As Lance mentioned, that's Social Security numbers, credit card numbers, certain types of healthcare data, what I tend to think of as fairly sensitive data that if somebody were to breach it and get access to it, people would really like to know because it's very concerning and personal to them. If that happens, if you have unauthorized access or what's defined as a breach, you're required to notify your customers or the affected individuals. What we're seeing on that is an expansion. Those laws keep getting tweaked a little bit in each state or as the new ones get passed. It used to be you just had to provide it within a reasonable time to each individual affected. Most states now have elements in place that if a certain number of customers are being affected, 500 seems to be a pretty common theme, but I've seen at least one as low as 100. If you have 100 individuals have to be notified, then you have to either notify the Attorney General in your state and or issue a press release to major media in your area. So that can definitely impact kind of how much notoriety a breach has and how much cost can come on that. The other thing that shows up on these that hasn't had a lot of traction before now is that a lot of states have an obligation that if you're holding this type of limited personal data, you have to have reasonable security measures in place to protect it. Generally, those only come into play after a breach has occurred. Then an attorney general might come in and investigate, or it'll be the basis for a class action lawsuit if you fail to properly notify them. It's hasn't seen quite as much traction with specific legal liability on that. But one of the issues we wanted to highlight that is applicable to everybody is that that's not the only cost you can face when you have one of these. So even if you're in a state that hasn't adopted the more comprehensive laws, the cost of a breach is still fairly significant to where a lot of times you're going to be better off trying to proactively limit the risks of a breach more than trying to wait and see and be reactive to it. And Lance, I think you had an example here of kind of how convoluted some of those costs can be and unexpected in a lot of cases that you were going to go over there.
Yeah, I think, one thing, example we share, fortunately, we have not seen specific examples affecting equipment dealers to date, so we'll continue to cross our fingers about that. But we have, we do a lot of work with in the restaurant industry as well, and restaurants a lot of times have franchisors and franchisees, which, can be somewhat analogous to a manufacturer and dealer relationship. And, we represented a group of franchisees that have all, do credit card transactions just like you all do with your customers. They experienced, there was a breach relating to their business system. And they had a common business system in connection with their franchisor. What happened was the credit card companies ended up having to, they got complaints and they ended up having to report and address the breach and do an investigation, refund money to customers, notify customers, et cetera. And what happened was, without a lot of knowledge by the franchisees got contacted by the card processor and said, "Hey, here's your bill." And the bills range from several $1,000s to tens of $1,000s. And we got contacted by these franchisees to try to help them out and deal with the issue. But the issue that everyone faces that takes credit cards is that you all have contracts with card processors that have indemnification obligations. And so these restaurant companies or operating companies were actually obligated to pay the credit card processor back for some of their costs that they didn't even incur. And at the same time, it turned out that the issue, the root cause of the issue, it seemed to be coming from a technology fix that had been pushed down through the business system by the franchisor. Okay, so imagine that was your manufacturer if you're sharing a business system or a component of your business system, and the root cause ultimately came from the manufacturer. In this situation, we then had to then go try to seek, the total exposure to the franchisees was over $150,000. So we were then forced to try to go after the franchisor and actually had to pursue legal action to try to get reimbursement. And so you can see how there's a tangled web where there can be a lot of dollars involved that may not be even your, particular location may not be too many, but when you add them all up, it's a significant number. And you may have to fight between multiple parties to try to get reimbursed, even though it may not have been your particular issue to begin with. And so we'll talk a little bit more about that later. But this is a real issue that can have some significant cost to businesses.
Yeah, and so that's right now it's a relatively limited amount of data that the law is specifically requiring you to protect. And one of the things we're seeing as we transition to these more comprehensive laws in the future is that the scope of that data is going to be expanding significantly. Lance, if you can skip ahead there. Next one. So with these new comprehensive state laws, as we're calling them, they really apply far more broadly. It's not just social security numbers and credit card numbers and key financial information. So this top definition here comes out of the California law, and so it covers any data that identifies, relates to, describes, is reasonable capable of being linked directly or indirectly with any consumer or household. And you look at that initially, and it covers kind of anything that's potentially capable of being indirectly associated with an individual. So I've got a lot of clients that are trying to figure this out. Is their website collecting IP addresses, is that covered by this law? And California Attorney General's opinion is it is. The other part to this is the consumer or household piece. And you may read that and think that it only applies to Facebook and those that are dealing directly with consumers primarily. But the California Attorney General has indicated that even in business-to-business transactions, if you get contact information of an individual that is a California resident in connection with your business transaction, then that is potentially covered, in their opinion, by this law. There are certain very limited exceptions for what I would call true business-to-business transactions of data. But in most cases, if there is a individual person associated with a piece of data, then the California Attorney General's position is that applies. So in the farm equipment context, I think it'll definitely apply if you've got a California resident that is purchasing a lawn and garden piece. I think it'll also apply to smaller farmers that are sole proprietors and such in a lot of cases. Then the AG's position is it's going to cover those customers' information. That's it's a fairly new law, went into effect in January 1st, 2019 originally. I expect there to be quite a few legal challenges and elements over the years to come to try and define exactly how far that goes. But at this point, the California Attorney General is taking the position that it's very broadly applicable. So as I mentioned, the current California law, the California Consumer Privacy Act, is currently in effect, and it came into effect in 2019. Last fall, California voters approved the California Privacy Rights Act, which expanded that and added a new dedicated body to enforcing it, and a few other elements we'll review. And then recently here, a month or two ago, Virginia became the first state to pass another version of this, the Virginia Consumer Data Protection Act. So they all come up with these very lovely, easy to pronounce acronyms in each case. Both of those last two, the new California one and the Virginia one, are going to come into effect in 2023. So they're not immediately applicable, but as we saw with laws coming out of the EU and with the current California law, I would expect that later this year and early next year, there'll be quite a bit of activity with a lot of vendors and others starting to push down requirements. And then in particular, if other states are also adopting them, they may all try to target this 2023 date it's looking like. So specifically with the California law, I wanted to go into a little more detail here of kind of how it applies and what some of the elements are that you have to comply with on it. In relevant part to this, it's got a couple of different triggers. The main one for equipment dealer purposes is that it applies to any company with more than 25 million in annual revenue. And that, in the California Attorney General's opinion, applies to your revenue globally, whether it's in California or not. If you have one California resident that you have data on and you exceed 25 million globally, they believe it applies to you. There's various arguments that lawyers will make over the next years related to that and how it'll actually work out, but at this time, that's their position. These laws are all kind of copying from each other, so we're seeing a number of common themes between them. And one element is that they're requiring any covered company to have a privacy policy. There are certain provisions and data practices you have to have in there. Probably most impactful is that you have to have, if you want protection from some of the worst requirements, you have to put in certain contract terms to have service providers. Under the law, those providers have to agree that they will only use your data to support you, and they won't go use it for their own business purposes separately. It's a little bit of an open question whether they can de-identify it and then use it as more of an aggregated piece, but we'll see. If you don't get those right contract provisions in, then they are a third party, and in a lot of cases, any transfer of data there will be considered a sale under its very broad definition. The other thing we're seeing in all of these laws is these very specific consumer rights, or data subject rights, they're called sometimes. And essentially, they require you to allow your customer to access any of that very broad types of data that you have about them, to correct it if there's any errors or make changes to it. And those two are, somewhat helpful in many cases for your business, to give them some access and to get corrections and updates. The two that I've seen the most challenges in for companies to comply with are the second two. You give customers a right to delete their data, and there are a number of exceptions. In particular, if you still have a contract outstanding, such as a warranty that you still might have to provide service on, there are certain exceptions. But if you don't have a valid excuse, then you have to delete all of their data that is identifiable to them. And actually being able to go through your system and effectively delete that is extremely challenging. And it's we're waiting and seeing how thorough you're going to have to be to meet the California Attorney General or the successors enforcement requirements when they come looking. The other piece is you have to give consumers the right to opt out of any sales. And you may think of that as, you're not selling data for money all the time. In most cases, you're providing equipment dealer services related to equipment and incidental data services related to that. You don't really sell the data. Well, the problem is that California defined a sale as any transfer of data for consideration, whether monetary or non-monetary. And so essentially, if you are getting any form of discount or there is any exchange involved in your transfer of data to any third party, whether it's a service provider or not, it arguably could be considered a sale. Now, there's one way to read that it applies to pretty much every service provider relationship out there, unless you just bought it off the shelf, particularly if it's a cloud service provider or something like that, then they could be implicated. Now, the one exception we have categorically is that if you fit this service provider element in your contract, then it's not a sale. And so you don't have to give the right of opt-out. Where it's left people in a lot of cases is, does this mean if I have my business system through a cloud provider, do I have to allow customers to require me to opt out of using my standard business system, because that could be considered a sale? At this point, it probably is not if you aren't getting significant concessions. But in the case of, say, a manufacturer provided system, it's not as clear at this point, and we're still kind of waiting for clear guidance on it as to how the AG is going to look at that on whether it's a sale or not. Interestingly, within the CCPA law, there is a specific exemption for car dealers and manufacturers related to warranties for service work. That doesn't appear to be applicable to farm equipment, but they thought it was worth their effort to get a specific exemption applicable to theirs, that those in and of themselves are not considered sales. We'll see where that develops and how that gets applied in other similar contexts going forward, but it's an interesting one. One element that California did put in place is there is a very strong private right of action, but only for breaches related to an actual data breach. So if you fail to meet the contract terms, if you don't provide one of the consumer rights appropriately, then your customer cannot sue you for that failure. They can only sue you if there is actually a data breach related to your failure to have these correct terms in places. So that somewhat limits your potential liability scope on this, particularly relative to, say, a class action. If somebody were to try and just scan the universe of all providers that they could go after, and there are plaintiffs firms that are doing this, it's a lot less enticing to get attorneys trying to drum up business for themselves to come after you with. Some of the things that the new law is going to bring into place is that it increases the amounts of potential penalties that the AG's office or its successor could bring into place, as well as there's currently a 30-day cure period for non-data breach issues. So if the Attorney General sends you a letter saying you need to fix your consumer rights and give them access to data, if you get it fixed within 30 days, there's basically a no harm, no foul at this point. That's going to be going away in 2023, though. And additionally, you can have requirements that you'll have to audit your own data security practices at least annually, somewhat dependent on what kind of data you have, and we're still kind of waiting for clarification on how that's going to actually apply and what documentation you'll have to have in place. So pivoting from California to Virginia here, one of the issues that came up in theirs that's potentially been very beneficial to equipment dealerships is that they put some broader exclusions. There is no revenue-based one like in California. And in particular, they exclude any employment-related data. So as Lance had mentioned, this one isn't going to apply to that employment data. California's got various pieces. Some has been limited, some hasn't, but Virginia is just categorically excluding it. As well, this only applies if you have 100,000 consumer records. So I suspect most dealerships will not trigger that one in and of their own. However, Virginia did adopt a slightly different formulation of kind of the common ownership definition. In California, you have to have common and shared ownership through common branding in the way you operate. So a dealership with the similar name. Virginia formulated theirs as having common ownership or having common branding. This is a very new law. It only came into place about a month or so ago. There hasn't been a lot of discussion of this, and I'm not entirely sure whether they intended for a substantive distinction on that, but I am concerned on the potential relationship that could be shown between manufacturers and dealerships in that you do share some common branding. And in that case, I suspect the 100,000 consumer records could be triggered if it was a manufacturer and every one of their franchise dealerships. So we'll see where that goes, but it's definitely something we're keeping an eye on. Similar to California, you've got, if you are covered by this law, you have to have certain privacy policy provisions in place and certain practices. You're supposed to limit your data to what's reasonably necessary. They use a term processors that's somewhat similar to service providers in California. One of the big differences is that there is no private right of action. So even if you have a data breach, the only party that can come after a breaching party of the VCDPA is the Attorney General. And you still have a 30-day cure period. So again, that helps, particularly in a non-breach scenario, that you'll be able to hopefully avoid specific legal liability, even if you had something that wasn't quite perfect. So these are some of the key issues: this private right of action, the applicability issues. These are issues that we're expecting to see play out as other states start adopting these types of broadly applicable laws, where I think particularly the associations and individual dealerships even could be able to potentially lobby for some exceptions to hopefully exempt some of your operations, at least from some of the more specific requirements that are really targeted at, the Facebooks and Googles and Microsofts of the world. So it's something you want to be aware of, and it would be a good idea to be active on trying to, identify it and stay ahead of it as it comes into different states. So kind of pivoting from Virginia, looking at Canada's requirements, I suspect we have a few dealers from Canada here. They have a law that predates most of the United States comprehensive laws here. It uses a lot of different language, but the net effect is very similar to California's in a lot of respects. It's any information related to an identifiable individual that's Canadian resident. You have to have consent, is the way they present it, but in most situations you can get implied consent if it's consistent with consumer expectations. And you have to provide opt-out if you are transferring data onwards, particularly outside of Canada. That's an area that's received a lot of attention from commentators and such, but hasn't seen a whole lot of enforcement that we've seen to date on it. In particular, one of the things about the Canadian law is that there is no private right of action for it, generally similar to the Virginia law. So it's challenging for an individual customer to force someone to comply with it in every specific detail because you're waiting for the enforcement agency to bring an action against it, somewhat similar to what we anticipate seeing out of Virginia. So one issue that in particular Lance and I have been keeping an eye on in these laws is that each one of the US comprehensive laws, as well as the Canadian law, has a concept in it called data portability. And what that is it states that you have to provide copies of personal data to consumers in a, quote, readily usable format that allows the individual to transfer that data to another company and utilize it. these haven't received much traction. They are highlighted as a very consumer-friendly thing. It's usually the example of they want to be able to, take your information from Facebook and take it to a competitor. There's a lot of technical challenges with this. It started originally with healthcare to try and say you could take your medical record from your doctor and take it to another doctor and have them review it. That hasn't worked well. I can tell you from a number of concrete examples, it's just really hard to make the systems talk to each other. And even like Facebook, what is a like on Facebook similar to on Twitter exactly, or a post, and they don't have the same functionality, so it's really hard to do it. However, there is this requirement in each of these laws, and they keep getting enacted, that could carry some traction, particularly if a private right of action comes into place to where a consumer could sue demanding it. In particular, are concerned about it in a similar way to a right to repair element, where a customer could say, I want all of my performance data to be taken out into my own system to analyze, or I want to be able to take it to an independent service company or mechanic on it to look at data. And so this is something we're definitely keeping an eye on, but we're not quite sure how it will apply yet, but it keeps getting enacted without anybody really knowing what it's going to mean or how it's going to work. So kind of giving you an overview of what's currently in place in these two main states. What I want to highlight here is how this seems to be expanding fairly quickly. Washington in particular, everybody had figured they would be the second one to pass it. Similar to California, they've proposed something for, I think, the last 3, maybe 4 years running, and they've advanced quite a ways each year, with the biggest issue being the scope of the private right of action. And the last version that got passed, I believe, in the Washington House, had a broad private right of action that any breach of one of these comprehensive laws could be subject to a lawsuit from one of your customers. The Senate wouldn't go along with that. It's currently kind of held up, possibly dead for this year, but we'll see where it goes. But this is definitely an issue that is showing up. We've got other states, Florida in particular was advancing a law as of a week ago, when I last looked at this, that could have a significant impact. And as Lance mentioned, there doesn't seem to be a strong, red versus blue element to where these are showing up, in that they're being adopted or they're being proposed in Tennessee. I think there's one in Missouri a little bit. Texas has had one for the last several years. In a lot of cases, they're proposed bills, so they're in committee, and it's not clear how far they're going. But in the states that have passed them, in Virginia's, for instance, I believe it was passed in about 12 days. So they can go from just being a proposal to a fairly completed bill, and it's hard to modify it quite quickly. The auto industry, we've noted, is fairly actively lobbying on these to either try and create exceptions, as I mentioned in California, or to try and narrow some of the scopes in general. They're also providing some guidance materials to their dealerships on some of the compliance goals. However, they are not always as focused on it. In particular, they're not quite as concerned with kind of the long-term impact of keeping telematics data, that I think you guys will generally see a lot more of kind of recurring customer data over time and how that's going to interact with it. So there's some useful information there to kind of see how another similar industry is facing it, but it's not always the same structure. In addition, there's been a number of proposals for a federal law to kind of trump this state-by-state patchwork we currently have. To date, none of them have really garnered enough support to advance, because everybody's got competing agendas on it. The big tech companies were behind one a year or so ago. It got a lot of lobbying for about a week and seemed like it might actually have a chance, and then it died because, in part, the private right of action, as well as just kind of the actual scope of what you'd have to do to show you're compliant and who it was going to apply to. And there's a lot of cooks in that kitchen. So it could be beneficial, but there's also the fear that it would be far more onerous if we ended up with a federal law on this topic. So we'll see. But at this point, we're expecting it to continue to advance state by state. And at this point, I will be surprised if a majority of states do not have these laws in place within the next 3 to 7 years, essentially. But we'll see where it goes from there.
Great, thanks, John. I think what John has mentioned to me is that there's 15 to 20 states that are really kind of looking at this kind of thing even right now. And so for those of you that are following the right to repair dynamics, that map, it's kind of like whack-a-mole. Those laws keep popping up, and people keep lobbying against them, but there seems to be a clear consumer priority to putting legislation like this in place, and well, we know it's a little bit mind-numbing trying to figure out what do we have to do. It's something that we want to make sure we educate you. I think everyone's kind of learning together on this, and it's going to gradually become more clear as to kind of what steps we're going to have to take. And part of the reason for that is as you've heard John mention, there's not necessarily a lot of concrete legal action elements to these laws that allow your customers, for example, to sue you directly. And so, frankly, you haven't seen necessarily a lot of people put a ton of priority on this from a business perspective when we're talking about businesses like the equipment dealerships. You don't have a bunch of IT staff. You don't have an entire department to be focused on this, and so it's not going to be your highest priority. But the issue is going to come to you, I think, more quickly, probably in the area of wait a second, if the law doesn't necessarily hold me accountable and responsible, then what will? And I think the issue that you're going to face as dealerships is that you're going to have manufacturers and IT vendors, your business system providers, they're going to start pushing this stuff down to you, and maybe even pushing it down earlier before it becomes effective in some of the states, just because they want to get ready and not have an issue. And a lot of times in their contracts that you'll see is when it comes down to who's responsible, they're going to say it's not us. If we're handling, their words, if we're handling your data, the dealership's data, and if there's an issue with that data, that you didn't deliver it to us in the right format, you didn't have all the I's dotted and T's crossed, guess what? You're going to be responsible for making us whole if there are issues. You're going to have to indemnify us, kind of similar to that credit card processor agreement that I mentioned earlier. And so the reality is, a lot of times through your contracts, that as dealers, you're often going to be tasked with being responsible to comply with all the data protection laws. And so you're going to owe that obligation to your third-party partners or vendors, even if you don't necessarily, can't be enforced to comply with it by your customer. Part of that's going to be to implement security measures, which are getting more and more specific, and we'll talk about that a little later. Have responsibility for handling breach notification and costs. So all these things could get pushed down onto you as dealers through a contract, regardless of the actual loss. And so when you look at the kind of language in your contracts, kind of associating that responsibility to you, there's a couple, and this language, by the way, has been in many of your contracts for years, going back to your retail finance providers even, but there's a couple of approaches you see people use. The more common one is to have more of a generic, as the dealer, hey, you're responsible for implementing commercially reasonable security measures, okay? And so it gives you some discretion. But now there's also additions about, and you have to review those annually. And so what they're talking about is it's not a one-time deal. It's going to be a continual process as dealerships to be paying attention to data security and your security measures. That's, again, a contractual requirement. Some other agreements are getting more and more specific about what does it mean to have the correct data security in place, maybe going so far as to mandate certain access rights, certain password controls, firewalls in place. I mean, one even requires you to update antivirus patches at least every 24 hours. Okay, and so you can kind of see that this is not this kind of a living, breathing process change that, frankly, dealerships are going to have to start addressing as part of their business. And I know it's not fun, and no, it's not something we really want to do, but it's kind of a price that we're paying for having access to the data and some of the efficiencies and benefits it brings to the business that we conduct. So when it comes to figuring out what's next, and we're going to close with trying to go through, and I'm going to be mindful of time here, try to get through these things relatively quickly. But in terms of from your dealerships, what are you looking at as your next steps? And there's three main areas where I think dealers need to be paying attention to help manage risk in this area. One would be insurance. We'll talk a little about that, as there is some insurance available to help you, help protect you in some of these situations. The second item, and this is frankly the hardest one, the one that's going to require the most work, it's going to be to actually develop and implement and invest, frankly, in a data security plan and program. And that's probably the biggest challenge that dealers are going to face, is putting together the resources for that. And then a final one is actually mitigating risk through some contract terms with your customers. and that's certainly in bounds, and it actually isn't that complicated to implement. So we'll talk a little bit about that as well. From an insurance standpoint, I think people have this market has really evolved quite a bit over the last several years, and frankly it started as kind of almost like a throw-in on some property and casualty policies to have some breach cyber attack breach insurance. But what's happened is insurance companies are used to having decades of history. You think about property and casualty, auto insurance, health, life, where they can really estimate with pretty good accuracy what their exposure is going to be and then what their premiums they need to charge to help cover that exposure and make a little bit of profit. That's kind of thrown out the window when it comes down to data breach insurance. Okay, the cyber attacks and other kinds of data breaches have just kind of become astronomical, and the reality of what's happening on the ground is that the policies now are becoming really expensive, and they're becoming harder to get because the payouts have been a lot more material. In 2018, there was $1.2 billion paid out by insurance companies on data breach claims, which is a big number. But in 2019, it went up by 50% to $1.8 billion. And so it's really making insurers be very concerned about this area. In fact, some people are even questioning whether there's even going to be a marketplace. Is it even something that can be captured as a risk sufficient to be able to be in the business? And so one consequence of that for you as dealers, you're going to see premiums probably go up in this area. Insurers are getting a lot more particular about who they are going to issue these policies to and how they underwrite you. They're going to require a lot more comprehensive questionnaires about your data practices and security practices. I think, John mentioned to me he had a client in a different industry that had originally been quoted a couple $100,000 for a premium, a pretty significant sized company. But after they went through their questionnaire, the premium came back in the millions. And so insurers are absolutely paying attention to what you are doing in your business to actually secure your data. So there's really no kind of get out of jail free card anymore with respect to these insurance policies. And so that's a change that we're seeing in the marketplace. The other thing you need to be concerned about is the insurance is very customized. Okay, a lot of them really cover the data breach notification costs and possibly the help that's needed to do that, maybe to investigate. But there are exclusions potentially for different customer bases. Think about your customers having an issue versus the manufacturer's customer. So whose policy is going to cover? Because they may not cover both kinds of customers. A lot of policies are now excluding fines and penalties. The California laws scare the crap out of insurers, and the fact that they can assess fines. And so you're going to have a lot of that stuff excluded from coverage under your policy. And so just the idea is that you need to be cautious about insurance and how much it's going to do for you. I think it's certainly an important part of your plan, but it's going to require you to frankly focus on the next prong of what I mentioned, which is getting your own house in order in terms of how you manage data in your business, okay, which requires work on your part. And so there's a couple of components of that I'm going to cover fairly briefly. But the first piece of that, as you've heard John mention, is more and more of these laws are requiring you to have a privacy policy. And frankly, your customers and manufacturers really started to expect that. And the idea is it's basically you're telling your customer, what am I going to do with your data? How am I going to secure it? How can I use it? Okay, and with some of these state laws coming on board, some of you may need to update your policies to the extent you have them already today. But the reality is that most dealers are now under some sort of a legal obligation to actually have a privacy policy in place. And what that means is, it's a policy. So it's just like any other policy you have. You get to adopt it. It goes into effect when you post it. You can modify it. It's a living and breathing document. There's still a lot of flexibility as to what you can have in those policies. But you have to remember that these are commitments you're making to your customer. And so you got to be prepared to live up to those commitments, which is the back half of what we're going to talk about, which is the data security plan. And so be careful what you put into those policies to make sure that you can actually comply with them. But you do have the flexibility to change them over time, and that's going to be necessary as this area is evolving. In terms of the need, we've already talked about the legal obligations. You've got your customers and manufacturers are now really expecting these to be in place as well. They can provide you some benefits. I mean, you can say that you're going to be able to use the data. You clarify that you can use their data for your business purposes, and that's a positive thing. But one thing I would also remind you too is as you go back and kind of take a look at where you're at in your dealership as it applies to a good privacy policy. I still find a lot of dealerships that don't have privacy policies, and then a lot of them that do have privacy policies, or they think they have privacy policies, they do, but too often they're just relying on their maybe their website host provider to provide a privacy policy for them. And a lot of those that I've seen, you just need to understand those policies are really they're generic, but they're limited to just your data that's collected through your website, and that's not necessarily going to be good enough. You're collecting a lot of data in your business from other means besides just your website. And so when I'm talking about a privacy policy, I'm really talking about a more global policy that really talks about all of the data that you collect in your business. So I encourage you to take an inventory of what you have in place today and look at whether you need to make some changes there. The other component of this that's really critical for dealerships is to really take a look at your data security program. And this is if you made a commitment to a customer or you have an obligation of the law to keep things secure, well then this is how you're going to do that. Okay, it's an internal program that really needs to be documented. It says, hey, we're paying attention to this and here's what we're going to do. But along with that, as important as that, is that you've got to assign someone in your dealership to be accountable to actually put this in place. Okay, if you don't have anyone that owns it, it ain't getting done. All right, and so that's going to be maybe a CFO or maybe it's an IT employee that you need to make them accountable, and they're going to be responsible for actually making sure a plan gets developed. But then you've got to not only develop it, you got to talk to people about it. You got to implement it with your employees. Everyone's got a role to play in this. It may not be that complicated of a role, but they got to understand it, and there's got to be some training. And so one part is identifying what the issues are. Second step is then figuring out what do we need to solve the issues to help protect our data. The third part is to actually communicate and train with your employees. Okay, so there's a lot of steps that goes into a data security program. And as John's mentioned, a lot more, this stuff is not just because our customers want it. Now we're seeing the legal obligations they're following, and we're seeing the contract obligations they're following with financial penalties if we don't have this stuff in place. And so my big message to you on this today is that do not sit on this thing, be ready to start acting, because this is a building block kind of scenario. We're not going to go backwards, I don't think, in this area. So what you should be doing is starting to think about data security today, your best practices, start building, and then you'll be in a better position to adapt to changes that come down the road as people continue to come out with improvements, I'll say in air quotes, about how you deal with these things. I mean, it may be painful, but there's going to be consistent changes in this area, and you don't want to be starting from square one. Because there will be gradually ratcheted up penalties in this area, and so the time to act is really now, where you start thinking about this to get a program in place. And as I mentioned earlier, it's going to actually have an impact now on your insurance premiums as well. So to the extent you want to rely on both, you need to actually take some action. And as you put together your plan too, I do want to make sure I draw attention that we've talked a lot about cyber attacks. That's what gets headlines. But when you look at a security program, some of your contract language says a physical security program too. So you got to think about things like stolen computers, employees leaving you and taking data with them, people just digging through your trash, your third parties. Okay, if they have access to your system, a lot of times people get access to your system through third parties that you think are trusted. Okay, but maybe their system isn't as strong as yours. They don't have the same protections in place. So you're going to see more about requirements to make sure that your third parties that have access to your system are actually compliant too. And so there's a lot of people that are going to be touching that program to make sure you're really, really taking care of data security in your business. And so, and then I want to wrap up with the last topic, the last kind of the three-legged stool that dealers should be thinking about here is to also be looking at your contract terms with your customers. Okay, they're really, you're getting terms pushed on you by your vendors and by your manufacturers, and there's nothing that says you can't also push some terms down onto your customers. And dealers do a really good job of making sure they sell their used equipment as is, and they don't do anything beyond the warranty on new equipment. But dealers do not, just being bluntly, dealers for the most part don't do a great job of addressing the same considerations when it comes to the other stuff that you sell. Your services, okay, subscriptions with, that come along with data services that are now offered. There's a lot of things that you do that aren't necessarily equipment sales anymore, and there can be liability associated with that. And so there's nothing wrong with pushing terms on your customers that may limit their liability to a refund of what they paid you. Okay, that's not much different from what a manufacturer might do with their warranty. There's also, you need to understand that you've got manufacturers that are actively disclaiming warranties. If they've got software packages, they're not standing behind them like they are their tractors. Okay, and they're going to disclaim those warranties. So you need to be thinking about, if I'm reselling that stuff, do I need to disclaim the warranties too, just like with used equipment? My answer to you should be yes. You should, because if you don't, you're caught in the middle of maybe legal exposure to your customer, and you may have a manufacturer or software provider that actually doesn't have legal exposure. They may take care of stuff from a business standpoint, but they don't necessarily have the legal exposure what you do. And that you may get whipsawed in that situation. And so the only thing standing in your way there is to make sure you adopt contract terms that help limit your exposure in those areas. So there's a number of things you can do that's pretty simple, frankly, in terms of adopting contract terms, and then you've got to push it down to your customers. And as you do that, it's bound to be beyond the scope of what we're talking about today, but I encourage you to start looking at electronic contracting practices similar to what you're using with manufacturers and finance companies today, thinking about adopting those same kind of strategies and technologies with your customers to make it easier to get them signed up on new terms that actually might help you out. And so hopefully today, we've covered a lot of ground. There's a lot of area that's changing in this world, hopefully we've stressed enough that there's some important things that you need to be thinking about in your dealership. It's not the fun stuff you do in the dealership. There's no doubt about it, but it's something that is going to become frankly a liability and risk management issue for you as you move forward. And so it's something I think every dealership needs to be thinking about, a little more education in this area, and then taking some additional steps to get ready for what's coming down the road from a regulatory standpoint. So with that, hopefully you found that information helpful as an update. If there are any questions, we can certainly take some time to answer those now. Ben, do we have any questions?
Thank you, Lance. Yes, we do. We have a few questions that we're going to get started with here. We have a few minutes here for a quick Q&A. And one of the questions that did come in essentially asks, I'll paraphrase here, for dealers in states that don't necessarily have these laws requiring them to work with customers on moving the data around, how do you recommend they talk with customers who are concerned about their data? How do you recommend they handle maybe requests to delete customer data where they aren't legally required to?
One thing I think that's one thing you want to talk to there in terms of the deletion of data is in the complicated areas. A lot of the data that you have may also be tied up in terms of your manufacturer data as well, in terms of who's housing it. And so I think the first step in that is to have an understanding as to really, do you have the authority as the dealership to delete that data? And so I think the first step that I'd recommend in that situation is to make sure you're in partnership with your manufacturer to get an understanding of what their policy is relating to that before I do anything else.
Great. All right. Something else that we were asked about was when it comes to data security, and this didn't specify digital or physical, but for dealerships who are maybe just beginning to look at the issue, what are some of the first steps you recommend that they take when beginning to implement, strong data security at their dealership?
Well, there are a couple of ways to go about this. I mean, there's the one element is to look at and understand the actual technical tools that are available to you. But I think the other piece of this is the hard part about this in terms of getting your arms around it is to actually kind of do an inventory of where's the data collected, who's got access to it, and how do you gather all that information. And one of the things that we actually had worked on with the Western Equipment Dealers Association a few years ago was actually putting together kind of a project management plan and program to help you get your arms around that. So I think taking an inventory about that is probably a good first step. And ultimately it may lead to hiring consultants to help you get your arms around what what are the best practices and what do you need to institute? But there are some materials available that can help you kind of take an inventory of what's going on in your business, and that's probably the best place to start is to try to get a checklist like that to start going through, because there's no kind of cookie cutter program in place that's really going to help you adopt your own data security plan.
Yeah, I just echo on that I'd recommend taking an inventory of both what types of data and how they come in, as well as a full inventory of what systems they go into, and then where are they physically located or who has control of them. So there's kind of 3 steps to that inventory in particular that you'd really want to think about as far as a good compartmentalization of here's what we've got in scope.
Great. All right. Well, thank you, gentlemen. That is unfortunately all the time we have today. If there are any additional questions that anybody would like to have answered, you can email myself, bthorpe@lessitermedia.com, and I can pass them on to Lance or John. Today's presentation and audio will be made available on the Farm Equipment website in the event anyone would like to go back and review it. You can check your email and the Farm Equipment newsletter for more information. And on behalf of Lance and John, the WEDA team, and Farm Equipment staff, thank you so much for joining us for today's webinar. There will be a short survey that pops up once you leave the webinar. Please let us know what you think, and you can always reach out to me directly with any topics you'd like us to cover in the future. Again, that is bthorpe@lessitermedia.com. Thanks again, everybody. Thanks, John and Lance, and everybody enjoy the rest of your day.